Hi, I'm Isaac Shutt. I'm an estate planning and probate attorney based in the Dallas, Texas area. I'm a licensed attorney both in Texas and in Wyoming, and I only do one thing, estate planning and probate. I feel like that makes me qualified to give you really good advice about estate planning in Texas. Now, here are 3 things that you should never put in your will in Texas. Number 1, don't get too specific with who gets what. And what I mean by that is, when we see a lot of DIY or online wills, they say, I give my house to this person, my car to this person, and my account to this other person. Well, the problem is that when you pass away, conceivably you have some other asset. And because of that, the judge is required to find that that's what's called a partial intestacy. And what that means is that your family is going to have to probate your will and follow the entire legal process as if you didn't have a will. So you've just doubled or even tripled the work. So you want to make sure to don't piecemeal give away stuff in your will, give away percentages or fractions so that we know that everything's been given away in your will. Number 2, careful with how you do that disinheritance. I know that it seems really fun to say that that son that you don't want to inherit anything gets $1 if you die, but here's the problem. If you give that estranged child $1, you've just given him a bunch of legal rights. He's now a beneficiary. He's entitled to notice after you pass away. He's entitled to be kept in the loop about what's going on with your estate. He now has standing to make all kinds of legal demands against your family and your estate after you pass away. So if you don't want your kid to get anything, then don't give them a penny. Don't give them anything, because that would just be making things so much worse. Now, when people come in and they really don't want their kid to get anything, and they want a way of having an ironclad disinheritance, the way they can do that is basically give that kid enough money that would incentivize them not to contest the will. Because in every will that we do, we have a no contest clause. And what that means is, if they try to dispute what your executor does or the validity of your will, they forfeit whatever that amount is that you gave them. So if you really want to make sure that that estranged child is not going to be a problem for your estate, either leave them nothing or leave them a significant amount and have a no contest clause in your will. Thirdly, people mess up their beneficiaries all the time. It's crazy to me how often this happens. So the third mishap is having what I call beneficiary overlap. So here's what I mean by that. Let's say you have an account at Fidelity or Schwab or Vanguard. All of those really awesome financial institutions have beneficiary designation forms. And on those beneficiary designation forms, that's going to trump whatever your will says. So, for example, the mistake that we see people do is they designate on those forms the executor they've picked in their will. That's a huge mistake. That executor is not obligated to split the estate, that account, in percentages with that Fidelity or Schwab or Vanguard designation. Whatever you have on file with Vanguard or whoever is going to trump what your will says. So be mindful of that. If you want the account split up, then your beneficiary designations need to have your account split up. If you want the beneficiaries of your will to get everything that you have in your Fidelity or Vanguard or what have you, then simply list as the beneficiary my estate. And so then that account will pay to your estate and be divvied up in accordance with your will. But don't think that having a will, even if it's later dated, is somehow going to trump whatever you have in your designated beneficiary, because the designated beneficiary forms on file with those financial institutions always trump. So let's recap. Be careful about how you give away property. That's number one. You need to make sure to give away the entire conceivable estate in your will. Number two, be really careful about how you disinherit somebody. Don't do this cutesy, I give you a buck kind of thing. It might feel great, but it's creating massive headaches after you pass away. And number three, avoid beneficiary overlaps. What I mean by that is whatever you put on your beneficiary designation forms for the financial institution does trump what your will says. Again, I'm Isaac Shutt. I'm an estate planning and probate attorney based in Texas, and all we do is estate planning and probate law. We'd be really honored to hear from you. So check out the links below where you can learn how to get in touch with us. And if you haven't already, subscribe to our videos. We're doing a lot of videos coming out soon, and we love to have more subscribers.